Hello, everyone. Welcome back to Immigration and Jobs Talk Show. I am Napasa Pradhan, and I'm going to be with you, your host, for an hour or so. And before we start off with today's webinar, I have this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, dearest friends, welcome back to Immigration and Jobs Talk Show. And yes, I'm very excited to have you with us today, wherever you've joined us from. We are streaming live right now on YouTube, LinkedIn, and Facebook. Thank you for joining. Don't forget to uh, comment because you can also participate in this webinar if you have questions regarding this topic, which is a very exciting topic for today. It's a critical topic as well that impacts so many families, actually. So, sponsoring a spouse or parent, what are your options? We are going to dive into this topic today with none other than our guest for today. And we are very fortunate to have with us Attorney Prashanthi Reddy, the founder and expert in immigration law who specializes in both business and family based immigration. Prashanthi, thank you so much for joining us once again today.
You're welcome, Nipasa. It's great to be back.
Absolutely. So, yes, this is also a very, very important topic, critical, because many folks out there in the United States, immigrants, they are facing issues regarding this sponsoring a spouse or a parent, and about also staying there in the United States. So, it's going to be a very critical topic. So, Prashanti, what can folks out there expect from this webinar today from us?
So basically, today we're going to be talking about immediate relative, green card, family-based categories. So if you are a U.S. citizen, you can file for your spouse, parent, or child. If you're a permanent resident, you could file for your spouse. If you're a U.S. citizen, there are also other categories that you can file for, but those categories are not current. For example, you can file for your brother and sister. If you're a U.S.
Mhm.
citizen, you can also file for your married children, but again, that's not current. So let's just stick to immediate relatives, that is spouse, child, and parent of US citizens, and also another category which is F2A, which is spouse of uh, green card holders. So we can talk about that today, since
Okay.
that. I guess it's most productive as the dates are available for those categories.
Surely we will explore today these different pathways available for sponsoring your spouse or parent, especially your immediate relatives, as Prashanti has already said. And we'll discuss the necessary steps and maybe address some challenges as well. And if you are also navigating this process, please feel free to drop your comments because we will be very happy to take them today in this session. So let's get started with our conversation as always, Prashanti. And I have a few questions. So let's get off on this first question I have for you.
Sure.
Could you walk us through the process of transitioning from a TN to a green card through family based sponsorship?
TN to a green card. So a TN is basically a non-immigrant visa, which a person from Canada can get. If you're a citizen of Canada, you can get. It's like a work visa, and if you qualify for those particular occupations that are listed under NAFTA, and if you have a job under those occupations, then you can certainly get a TN visa. The disadvantage of a TN visa is there is an intention to immigrate, and that's why that question is important. If there's an intention to immigrate on a TN, then while being on a
Mhm.
TN, can you simultaneously file for an I-130 and 485 without jeopardizing your underlying status? Can you travel on a TN? Um, Say if you have an I-130 pending, a 485 pending, then you don't really have to travel on TN, or you cannot because you have to file advance parole. But if you don't have a 485 pending and you only have an I-130 that you file, which is the first step of the immigrant visa petition, then is it an issue to travel on a TN? Um, TN does have an intention to immigrate. Um, However, if you're already in the US, and you are say, filing for a change of status to a TN visa from some other status, then there is a question in the form asking if there is an immigrant visa petition pending, and then if you say yes, they might deny the petition. Same way, if you're
Mhm.
traveling, again, it's discretionary, but they may conclude that you don't have the intention to leave, or that you have the intention to immigrate, and they may deny the TN visa. But it is again on a case by case basis, because the intention to immigrate clause for the TN is not as strict as it is for, say, for the visitor's visa.
Okay.
So being on a TN, there are still possibilities that you can immigrate.
Okay. Great. That must be good news. And do you have anything else to add more, like, I mean, for options for immigrating via TN visas?
The same thing, again, we are discussing about family-based petitions, right? So if you're a
Yes.
US citizen, if your spouse is a US citizen, and or your parent is a US citizen, or you know, you have a child who's a US citizen, who's
Mhm.
over 21 years of age, they can help you immigrate to the US.
Do you have anything to say about this recent, many Indian immigrants were sent off from Canada, and many of them are entering the United States and also the UK. Do you want to say anything about that as well?
I don't know what you're alluding to, Nipasa. I haven't heard of anything of that nature where Canadians are being sent to the US. Can you be more
No,
specific?
because yes, there have been some changes in immigration policy in Canada. So that is why Indian nationals are, I mean, Indian immigrants are facing this. So I thought you would know.
No idea
Anyway,
about Canadian immigration. Sorry.
okay, no worries. But thank you so much for taking that up and for giving us a detailed explanation, Prashanti. Right. So moving on, I have another question. And if you could tell us what legal options are available for individuals who marry someone whose visa has already expired?
So if you are married to a US citizen, then even if you're out of status, you can still file and adjust in the US as long as you have entered with inspection.
Mhm.
EWI. If you've entered without inspection, then you cannot adjust status here. You have to leave the country, go through maybe the waiver process if you have unlawful presence. That is, if you've been out of status for more than 6 months, it becomes much, much more complicated. But if you are only out of status, but you've actually arrived into the country legally, meaning you've come on a visitor's visa and then your status expired, or you came on an F1 maybe, or you came on a H1, but you are not able to
Mhm.
maintain your status, then you can definitely apply for adjustment of status even after your I-94 is expired, provided that you're an immediate relative, meaning you are an immediate relative of a US citizen. Immediate relatives are, again, spouses, children, and parents.
Okay. So if you marry someone whose visa has already expired, this is going to be a problem only if you're coming dependent on that person's visa,
No, it will be a problem if you entered without inspection,
without
meaning
inspection,
if you cross the border
illegally.
illegally without being inspected at the border.
Okay. Thank you, Prashanti, for taking that up as well and for your detailed explanation. Moving on, Prashanti, now I have another question. But before we take up, I think I will quickly say hi to our viewers out there who have already dropped some questions. And hi, Catherine. We will take up your question. Thank you so much for dropping in. And yes, stay tuned with us. We are discussing about sponsoring a spouse or a parent today. And Lali, thank you so much for your questions. Stay with us. We will take them up for sure. So my next question for you, Prashanti, is what steps can an immigrant take if their U.S. citizen spouse is unwilling to assist their immigration process?
Not much, because the petitioner has to file the petition, sign the I-130 While you're filing your adjustment application and you're signing that, the petitioner is signing the I-130 application and also will be has to fill out an affidavit of support for you, the I-864. So without the U.S. citizen spouse supporting you, you will not be able to file an immigrant petition unless you're able to prove that there is abuse in the relationship. Then you might be eligible for filing a VAWA petition, Violence Against Women's Act. This is applicable for both men and women. So if you are an abused spouse, you can file on that basis, even if your spouse is not willing to petition for you.
Okay. Okay. So there's not much steps otherwise. That's it.
Correct.
Thank you so much, Prashanti, and thank you again for your detailed. Moving on, Prashanti, I have another question, and if you could tell us, which family members are eligible for sponsorship while once an individual becomes a U.S. citizen.
I guess I've been saying it all along.
Yeah.
Parents, uh, children who are under the age of 21, and this could include stepchildren as well, and adopted children as well, and parents. Um, and so for the US citizen to sponsor you, the US citizen has to be over 21 years of age. So they have to be an adult. So this is the relationship, and this is the age limits for some of the categories.
Okay. Thank you, Prashanti. Thank you for taking that up as well. I have another question, but before that, let me tell you, folks out there, if you're watching us, you can drop your questions in the comments. We'll be very happy to take them up. Today, we are discussing on sponsoring a spouse or parent and what are your options. So far, so good. Prashanti, thank you so much for being so enthusiastic and explaining to us in details. I have this other question for you. Is it possible, to sponsor a new spouse after obtaining a green card from a previous marriage? And what conditions should one be aware of?
So this is the question is, and for those of you who don't understand the context behind the question, let me explain that. If you are, um, if you became a U.S. citizen and you got your green card through your first spouse by filing a marriage-based petition, and then you got divorced and you got your green card, citizenship, etc., and then
Mhm.
you're filing now for for your second spouse, but you yourself got your green card through marriage, right? But now you're the
Yes.
petitioner and you're filing for your spouse. There is a question in the forms which asks how you got your green card and whether you got it through marriage. And if you
Mhm.
say yes, obviously the scrutiny is a little higher for all marriage-based cases, not for other immediate relative categories, but for marriage-based cases, because of
Okay.
fraudulent marriages, sham marriages, which have become common.
Yes.
USCIS has a different standard when they're approving these cases. You have to show um, that there is a presumption of fraud. So USCIS presumes that there is fraud, and you have to prove to them otherwise, that there is no fraud in the marriage. It's a bona fide marriage, and the marriage took place for the purposes of marriage and not for the purpose of obtaining a green card, right?
Green.
Um,
Mhm.
so when you obtain your marriage through green card, and then they might think that and then you got divorced and getting married again, then the presumption is even more that the marriage that you got your green card through is fraudulent. So they might ask questions around that marriage before they even though you're a US citizen, before they allow you to apply for a green card for your spouse.
Okay.
They
Yes.
might question the they also might question the present marriage, whether it's
Mhm.
fraudulent or bona fide. So get ready for more scrutiny.
Right, right. And I mean, I've seen in movies and all that where, both the partners are actually questioned. thoroughly. Where I mean, maybe even getting to know their personal interests and stuff like that. Does that happen?
So, in a marriage interview, if they are suspicious that the marriage might be fraudulent, they separate the spouses and they ask them questions independently. Um, and then tally the questions. So yeah, they do separate both the spouses if there is some suspicion of fraud, and
Mm,
they conduct a more thorough interview.
interesting. Thank you so much, Prashanti, for taking that up and for the deep. All right, moving on. Tell us about what are the income requirements, for sponsoring a spouse or other family members for immigration.
So it depends on the size of your family. So if you have to be obviously US citizen, but it's based on the poverty guidelines, and you have to be uh, have 125% of the federal poverty guideline. So
Hmm.
for um, if you have two members in your family, if your total household size is two, then your income requirement has to be at least 25,550. If you have three members, it's 32,000. If it's
Hmm.
four members, it's 39,000. Five members, it's 45,000. 52,000, 59,000. Eight members, 65,000, so on and so forth. So
Wow.
you have to look at the poverty guideline chart that's available online, and you can figure out whether you as a US citizen meet the income requirements to sponsor your immediate relatives to the
Hmm.
US. If you don't meet those requirements, then you can have in addition to you filling out the I-864, you can have another person fill out the I-864 who is willing to, and as long as they meet the income requirements. So you'll have an additional I-864. Also, you can have your family member, say your US citizen spouse marrying a H-1B holder, and the H-1B spouse makes more money than you do and meets the income requirements. You can have the spouse fill out a I-864A, uh, which is by a family member. So and then in addition to the I-864, they can fill it out, and you can then overcome the issue with reference to a lower income that way and still
Okay.
file your petition.
Okay. Thank you so much for taking that up, Prashanti. Once again, can you please tell us where can they find the poverty? What did you say? The list of
Poverty
income?
guidelines. The poverty
Poverty
guidelines,
guidelines.
just type it in Google, it'll come up. US poverty guidelines.
There you go, folks. Thank you so much, Prashanti, for taking that up as well. All right. So I have another question, Prashanti. And if you can explain the process of sponsoring a common law partner and how does it differ from traditional marriage-based sponsorship?
Well, you cannot sponsor a common law partner. It's as simple as that.
Okay.
So it is different, meaning that if you're married, then you can sponsor. If you're not married, you cannot.
Okay.
So
That's right.
if you're a fiance, then there is a fiance visa available. But if you're outside the country, but you're not sponsoring them for the green card. You don't get a green card, so you can apply for a fiance visa. It's rather hard to get because it's difficult to prove that one is engaged because there's no
To be
document
married.
required by law to get engaged. But marriage,
Right.
obviously there's a document required. So you have to prove that, and you have to apply for an I-129F
Mhm.
application. And once you get that, you can come into the US on a fiance visa, and then you're supposed to get married and file for an immigrant petition within 90 days of your arrival.
Okay. Okay, that's very interesting. And all right. So thank you once again for taking that up. And I think we should take up some questions from our folks out there who have dropped them in the comments. So we will take them up. But thank you so much, Prashanti, for Let's take this one from Catherine on YouTube for now. Catherine says, my husband already has O1A visa stamp. I got an interview for O3 yesterday in my home country, Hanoi, and it was refused. The consular officer asked to have my name on the petition I-797. She gave me 10 days to edit the petition with my name on it. So question is that possible to have spouse name on I-797 or the form just have O1 name on it?
So basically, if you've been approved for a O1 approval, the I-797 only has the spouse's name on it. And if you're applying for a dependent O2 visa, then basically you can apply for that outside the country without needing to file a petition, as long as both of you are outside the country. If you're in the country, then it's a different process, of course. Then you have to file for a dependent O1, O2 as well as O1. But if you're outside the country, then there's no need to file a separate dependent petition. You take your spouse's I-797 and then you show proof of marriage and you go for, apply for a visa interview that way.
Okay. Thank you so much, Catherine, for your question, and I hope you are satisfied with the answer. Thank you so much, Prashanti, for the detailed explanation. All right, so and now I think we should take up this one from Lally. This is also on YouTube. I need information about H4 EAD extension. My question is, can I extend my EAD without my husband's document? My H4 visa is valid till 2026, but my EAD will expire this October. Because my husband is not supporting because he filed divorce and it's not finalized yet, but I want to work to support me.
Yes, if you're not divorced, yet you are eligible to file for a H4 EAD and H4 extension. But be aware that the divorce might come through within a year, then you will be out of status. So it's important that you um, become independent of your spouse from an immigration point of view and apply for a status that allows you to do so, such as a H1, if you're able to do that next year and you're still in status, or move to an F1, etc., etc. So can you apply for H4 EAD without his help? Technically, no signature of his is required for you to apply for H4 EAD. It's your application, but you do need to show that you are in status. So if it's only the EAD extension, then I suppose you could file it using your H4 approval. Generally, we also include the marriage certificate and we also include the I-797 H1 approval of the spouse. They might sometimes ask for pay stubs of the spouse as well. So be aware of that when you file for your H4 EAD.
Okay. Thank you so much. And Lali, all the best. I'm sure you will figure out the best way possible for you. And in fact, if you want to contact Attorney Prashanti directly and maybe have a one-on-one session, more detailed with your case, why not contact her? Her details are scrolling on the screen. Her phone number is 212 354 1010. And you can even email her, Prashanti at reddyesq.com. And you can even go visit this website, reddyesq.com, to get to know more about Prashanti Reddy and the law offices of Prashanti Reddy. Thank you, Prashanti, for taking that up. All right, let's take up another one now. This one is from Imran, also on YouTube. My spouse has become US citizen and he wants me to apply for green card. Where do I start and what forms do I fill? If that matter if that matter to know, I am EAD based on VAWA, but I want to take my spouse support to file new application for green card.
So it's a little confusing because he's applied for VAWA that's based on marriage to a permanent resident or a US citizen. So are
Mhm.
you no longer married to that US citizen or permanent resident? based on which you filed the VAWA? And are you now, did you get married a second time to a US citizen spouse? If that is so, then as long as you entered with inspection, you can apply for the I-130 485. You can also withdraw your previous I-360 that you filed through VAWA and apply for a fresh I-130 and 485 as long as you entered with inspection. Yeah, so what is the question there? How do I apply?
She wants to be in the, but I need, but I want to take my spouse support to file new application for green card.
Okay, so you can do it. And you have to file an I-130 and 485 to be able to do it and show proof of bona fide marriage, as I was discussing that in in all instances, USCIS presumes that a marriage is a sham marriage, so you have to show otherwise by showing joint documents,
Mhm.
joint tax returns, bank statements, credit cards, health insurance documents, etc., to show that you are to show that you're living together. You can also submit joint leases or property documents to show that you have a house on both names. All these documents help
Okay.
to prove that you have a bona fide marriage.
All right. All right. Thank you so much for taking that up for Imran Khan. Thank you so much, Imran, for your questions. And I hope you got your answer. Okay. So, Prashanti, I have another question. And if you could tell us, which family members are eligible to sponsor someone for a 601A waiver? And what does this process involve?
So as I was discussing, if you are for some reason barred from the US, if you've
Mhm.
then you can still apply. It's not just being this is not just being out of status, but if you have been unlawfully um, present in the sense that you have been in the country out of status and you have left and then come back, that triggers unlawful presence, and then it's a problem to file. Or if you have misrepresented something with while filing for your immigration, or if you've committed a felony, then you
Mhm.
cannot file for a green card even though you have a US citizen spouse or other immediate relative. In order to file
Okay.
that, you'll have to file for a waiver and get that waiver approved, and that's called a
Mhm.
601 waiver. In order to file a 601 waiver, the qualifying relative must be a US citizen. That means it's only applicable to US citizen um, relatives.
Mhm.
A US citizen or legal resident who is a spouse, parent, or child of the alien who is denied admissibility based on criminal history, a US citizen fiance. So the qualifying relative can be a fiance, a legal resident who is a spouse, parent, or child of the alien who is denied admissibility, or a US citizen or legal resident, spouse, parent if the immigrant is denied for unlawful present or misrepresentation. So it depends on each category. So each category is different, um, and the requirements are different. So you have to show that there is hardship faced by the U.S. citizen if you have to leave, and that's the basis
Okay.
for the waiver hardship to the U.S.
So one
citizen.
you Mhm.
So a relative has to leave the U.S. For example, the hardship factors could be that the U.S. citizen has to leave the U.S. to be with you. Maybe the U.S. citizen needs medical treatment on a
Mhm.
continual basis that may not be available in the country that you're going to go to. Your country
Okay.
is, say, in a civil war kind of political upheaval situation, in a bad situation, so the US citizen may not be able to come there and live with you. You are the primary caretaker for an elderly, disabled, or seriously chronically ill relative, for example.
Mhm.
In that case, also you could show that you cannot leave the United States because you have to be with that relative.
Okay.
Education would be significantly interrupted or terminated for the US citizen. You would lose or be denied significant employment opportunities. or you have a minor child and you're the primary caregiver, and from a prior relationship maybe, and that there's no one to look after the child if you leave.
Mhm.
So
Okay.
those are some of the hardship factors that they look
Hardships.
at when you're filing for the waiver. So there again, I mean, this can be an entire topic because if it's a very large topic, but there in some instances you may be ineligible for getting the 601 waiver. And
Okay.
there, if you are filed, for example, a frivolous asylum claim, then even if you qualify for a waiver, they may not give it to you. Or that if you show that if it is determined that the marriage is a sham marriage, meaning that you are not able to show that the marriage is a bona fide marriage. If
Hmm.
you didn't attend a removal hearing, for example, you're in removal proceedings and you didn't attend the hearing, if you have a drug conviction, that is, if you've been convicted for drug possession or sale, that is, if you have a felony charge, and the felony charge is for drugs. If you are a member of a gang, um, then you can be denied the waiver. If you've made a false claim to the US government that you're a US citizen,
Hmm.
unless you can show that it was not intentionally made, and there's some reasonable basis to have made it because you thought you were a US citizen, then that could also be, you could be ineligible for a waiver.
Okay.
Or if you were unlawful for more than 1 year and you departed and then re-entered without inspection, then that you could be ineligible for a waiver. So these are reasons why you may not get that I-601 waiver.
Okay. Very interesting, Prashanti. I'm sure we will have maybe a detailed webinar on this sometime in the future for sure. Yeah, if it's fine. But thank you so much for taking that up. And I think it is definitely time to go for a short break. But folks out there, you can also contact Attorney Prashanti Reddy directly. Her details are on the screen. You can call her on this number, 212-354-1010, in order to have a consultation with her. And you can even email her, prashanti at reddyesq.com. Please check the spellings on the screen. Prashanti at reddyesq.com is her email ID. And you can also go visit reddyesq.com to get to know more about Prashanti Reddy and the law offices of Prashanti Reddy. And don't go anywhere, folks. We'll just go for a short break and be right back. And we'll discuss more about sponsoring a spouse or a parent and what options do you have. Don't go anywhere.
Are you an IT consultant seeking a new opportunity? We offer job placement services for US citizens, green cards, EADs, and visa holders. We also sponsor various work visas like H1B, E3, TN, and green cards. 20 plus years of experience in the industry, exceptional employee benefits, highly rated by our employees. Global presence with 200 plus recruiters and direct clients. Connect with us. Call us on the number 833 412 8472 or mail us at support@higheritpeople.com or visit our website www.higheritpeople.com.
Hello and welcome back, everyone, to Immigration and Jobs Talk Show. I'm Nipasa Pradhan, and today we are discussing about sponsoring a spouse or a parent and what options you have with none other than our guest for today, Attorney Prashanti Reddy, the founder and an expert in immigration law, who specializes in both business and family-based immigration. Prashanti, thank you so much. So far, so good, and it feels good that we are halfway through our webinar and stepping into the second half. Well, today We are exploring this topic, and friends, you can keep commenting whatever questions you have, and we are very happy to take them up. So, different pathways available, for sponsoring your spouse or parent, and we are discussing the necessary steps and maybe some challenges that we need to navigate as well. So, thank you once again, and Prashanti, I hope you're also having a good time today.
I am.
All right. So moving on, I have another question. And if you could tell us, is it true that there is no minimum income requirement to sponsor a spouse or children to the US?
So we just discussed that and we talked about the poverty guidelines, right? So there is
Yes.
an income requirement and it's depending on the household size, it ranges from 25,000 to 65,000. So basically an additional 6,000, for each additional person in your family starting from 25,000. So that's how you kind of roughly calculate it.
Mm-hmm.
So there is an income requirement, and also there is a law called the public charge law. In addition to the income requirement, and in addition to your family member filling out that affidavit of support, you could be denied a green card if you were ever a public charge or you have the potential of becoming a public charge.
Okay.
Public charge is a person who took money from the US government to support themselves or who were subject to long-term institutionalization at the expense of the US government. Say if you were in a nursing home, etc., and it was paid for um
The government.
by the US government. Yeah. So if you've taken any of those two benefits, SSI, which is supplemental income benefit, and if you were institutionalized for a long-term basis at the expense of the US government, then you may not get a green card, even though you have a person sponsoring you and even though that person meets the poverty guidelines. Um, Also, they're looking at whether there is a potential for you to become a public charge, and that's more tricky. Under the Trump administration, they had really increased the scope of this public charge law to such an extent that anyone who was not presently working, so if you had to file for your spouse who is a homemaker, or if you had to file for your parent who's retired, that would be very, very difficult to get approved.
Difficult. Hmm.
And the same thing could happen, if Trump is elected again. But as of now, the public charge rules are, uh, very common sense. They use common sense when they decide to approve or deny a case, and they're very
Okay.
reasonable with reference to public charge. So that's something to keep in mind.
Thank you, Prashanti. Thank you for sharing that with us. So, my next question to you, Prashanti, for US citizens looking to sponsor family members overseas, what are the different options available and how does the Form I-130 play a role in this process?
So if the person is outside the country, then you have to file a petition with the National Visa Center. You have to file an immigrant visa petition, and that's done online by paying fees, filing an I-130 with USCIS, and once it's approved, because you can't file concurrently if you're outside the country, then
Mhm.
if you've marked your petition as consular processing, NVC will automatically contact you, email you after the I-130 is approved, and you will be able to go online, pay the fee, fill out the form, submit documents, and once that is completed to their satisfaction, NVC will submit all the documents, send all the documents to the consulate, and then the consulate will send you a letter in the mail for an appointment where you then take all your original documents. And if your petitioning relative, whoever that is, should also attend the interview with you. Um,
Okay.
so you should go along with your sponsor to attend the interview. And that's the process for an I-130 immigrant visa petition. When you're outside the country, after the interview, you'll be given an immigrant visa package, which is sealed, and when you come at the port of entry, wherever you're entering at JFK or Newark or wherever it is, you will be then processed for a green card at the port of entry. They will take all the documents and process it, and then you will get a green card in the mail in 10 days or a month or so. So that is the process if you're outside the country. It could take a
All
little
right, all
longer
right.
if you're outside the country, simply because you can't file concurrently, number one, so you have to wait for I-130 to get approved. And then you have to wait for the consulate to schedule an interview, and there is delay because there's backlogs, because they
Yes.
have more interviews than they have time for. So that might cause an additional delay in your processing time.
Okay, okay. So the appointment dates are totally decided by them. It's not like we can have an option at all.
You have to apply. It's same as a visa appointment, non-immigrant visa
Okay,
appointment. The same thing is with the
okay,
well, actually, with the non-immigrant visa appointment, you can choose your appointment, or you most probably will choose the first date available because there are no appointments available. But with the immigrant visa appointment, they will send you a letter with the date, and if you're not available, you have to write to them to tell them that you're not available and why, and then they will schedule another date. But generally, people don't do that, because if they have to reschedule, then again you're significantly delaying your immigrant visa application process, because they may not have another date immediately available.
right, right. Thank you, Prashanti, for taking that up and for your detailed explanation. All right, moving on, I have another question, and if you could tell us, you know, is it advisable to become a US citizen before sponsoring a spouse, and what are the potential benefits or drawbacks?
Well, yes, if you can, but it depends on your situation. You could also sponsor your spouse as a permanent resident. If you're a permanent residence holder, if you're a green card holder, if you have a green card, you can use the F2A option and sponsor them based on that. The dates for F2A, since it's not an immediate relative petition, it comes under the quota. So you have to look at the visa bulletin to see what the dates are for your F2A petition. So it's definitely better to be, US citizen, because then you don't have to worry about the visa bulletin at all. But if it's going to take you another 5 years to become a US citizen, obviously it makes more sense to file an F2A application.
Okay.
F2A applications are not too bad. They're in 2021, so it's a wait of 2 or 3 years, and that's for the final action. If you're already in the country, if your spouse is in the country, then and if you're able to use the dates for filing chart, then you can at least file the 485 and get all the benefits of travel and work. And that's June 2024, so it's almost current.
Yes.
If they allow you to use the dates for filing table, which even this month they're allowing to use the dates for filing table. So for family based, it's much better, and they do allow dates
Okay.
for filing table more so than for employment based.
Okay. All right. Thank you. Thank you so much, Prashanti, for taking that up as well and for your detailed explanation. Moving on, who qualifies to sponsor a relative-based immigrant visa, and what are the specific steps involved? So this maybe we
So
can discuss who are not immediate relatives also, like
right, right. So in order to file for family based preference category, those which we already discussed, immediate relative petitions who qualify. And the
yes,
ones that require a visa are not immediate relatives, and they are unmarried sons and daughters of US citizens, spouses and children, and unmarried sons and daughters of permanent residents, spouses and children of permanent residents, unmarried sons and daughters 21 years and older of permanent residents, married sons and daughters of US citizens, and the last category is brother and sisters of US citizens. So these categories, based on the order that I just said, the backlog is, more and more. So when it comes to F4, which is brothers and sisters, the backlog is really, right now they're working on 2006 cases if you're an Indian national, 2007 cases if you are all other countries. So it's, you can see 20 plus years. And there's no guarantee that it will move every month. So, brothers and sisters, it takes forever. So it's as good as not having that category.
Not
Uh,
having, yes.
yeah, unless you're willing to wait
Look
for
for a
20 to
better
30
option
years.
instead, yeah.
Right. So those are the different categories. And in order to file, you have to file the I-130 petition. Then your priority date is the date that the I-130 petition was filed. And then you wait until your visa number becomes available. If it's already available when you're filing the I-130, you can file concurrently I-130 and 485. If it's not, then wait for the I-130 to get approved, then wait for your priority date to become available. Once it becomes available, either based on final action dates, if you're in or outside the country, or based on dates for filing if you're in the country, you file the 485 adjustment of status application, along with, proof that affidavit of support to show that your spouses or family members is able to support you. You provide their tax documents. You provide proof of relationship. You provide your status in the U.S. if you're presently in the U.S., because you need to show that you're in status, and your passport copy, and your birth certificate, etc.
Okay. There you go. I hope you have noted it down, friends, the specific steps involved. And this was regarding sponsoring a relative-based immigrant visa. Thank you so much, Prashanthi, for taking that up and for the detailed. Now, I have this last question from my end. And if you could tell us, what are the key steps to ensure a successful application when sponsoring US citizen parents for a visa?
Whether it be, we'll talk about parents first, but
Sure.
this question could really pertain to any green card petition that you're filing for family based. Um, for the parents, since we didn't talk much about parents, I think the main issue could be public charge, because parents are retired, so obviously they don't have the ability to work, or they will not be working. So USCIS is worried that they might become a public charge, or you might use public benefits for them. Public benefits, keep in mind, is not Medicare, Medicaid, that all that you can use anyway, um, or disability or anything like that. It is taking money from them, from the US government, to and not even food stamps, getting free food. It's actually taking money to survive, or it's long-term institutionalization, which could be a problem if the person is older. So other than that, it's you're basically showing proof of relationship. This
Mhm.
sometimes can be tricky. Um, you need a birth certificate. Sometimes the names of both parents may not be on the birth certificate, depending on which country you come from. And then for the mother, it's easy, because it's the mother's name is always there on the birth certificate. But for the father, sometimes you might have to do a paternity test to show that the relationship exists. Um, so those
Okay.
are some of the complications that can occur. Or maybe you don't have a birth certificate, and you only have you're only submitting secondary evidence, such as affidavits from people who know you and know who your parents are. And sometimes then you'll have to submit a non-availability certificate to show that the birth was never recorded. In that instance, USCIS might sometimes come back and ask for a paternity test to show that, proof that the father is the father, biological father. Also, with reference to adopted children, there might be a set of documentations. I mean, if the adopted child is filing for you as a parent, then there might be other challenges that you have to face because of that.
Okay. Okay. So, how common is otherwise, parent visa or adopted parents visa?
Parents visa is very, very common. A lot
Okay.
of US citizens are filed for their parents, especially after COVID.
Mhm.
It's become more and more common because children, especially if there's no one back home to look after them, children are often
Yes.
bringing their parents here so that they can look after them, worry free and not have to worry about them.
Right.
So it's become more and more common for,
Yes.
especially for Indian nationals, actually, to bring their
Agreeable.
parents to the US. Yeah.
Agreeable. Because, I mean, it becomes too far otherwise to attend, especially if it's an emergency, medical emergency.
Right. And if they
So,
are the primary caregiver and they don't have anyone
yes,
else taking care of them, and with a pandemic such as COVID, people realize that, the danger of
true.
health issues that people can, especially people who are older, which
Yes.
were previously not there. And now, with these pandemics and epidemics, people are overly cautious about
Yes.
their elderly family members.
So true. So true. Thank you so much, Prashanti, again for taking that up and for the details. All right. I think now we should move on to the rest of the questions from our audience. Thank you so much for being so patient and for joining us and for staying with us. So I'll take this one up. This is on YouTube from Kunal. I'm a permanent resident sponsoring my spouse for a green card, but I have a prior conviction for a DUI offense. I've since completed my sentence, attended rehab, and obtained a letter of recommendation from my probation officer. How am I worried? However, I'm worried that my criminal history might impact my spouse's eligibility for a green card or lead to an additional scrutiny during the application process. What are the potential implications of my conviction, and how can I mitigate any negative effects on our application? Shanti.
So, this is more of a problem if she was convicted of a DUI, your spouse, more
Okay.
so than you, since you're the sponsor and you're a permanent resident. Um, this could affect if you're filing for your citizenship because you're the applicant then. So you have to see whether it comes under petty offense, whether it's a crime against moral turpitude, etc., etc. Those are the issues that will come up when you're filing for citizenship. But when you're filing as a sponsor for her, um, her information is looked at more carefully as to whether she was ever convicted of a felony or any a DUI or anything like that, or
Mhm.
a crime against moral turpitude, which is what a DUI would be, even if it's not a felony. I don't think it should affect the application if
No.
you're the one who's been convicted. Um, yeah, there is no law which says that the they look at the sponsor's criminal record. They look at the immigrant, the person who's immigrating their criminal record. At least I haven't seen that coming up in my cases so far.
True, true. So they do a proper scrutiny of who's coming into the US. And Kunal, I think this is, thank you so much. I'm sure, Prashanti, this is a good answer, and Kunal must have got your answer. If you have further questions, Kunal, you can keep dropping your questions in the comments. But thank you, Prashanti, once again. Now I got this next question. This is also on YouTube from Ishita Vora. I am a US citizen sponsoring my elderly parents for green cards, but they've been living with me in the US on visitor visa for the past few years. My mother has a medical condition that requires ongoing treatment, and I'm concerned that if they leave the US for consular processing, her health might deteriorate. Can I apply for adjustment of status for my parents while they're in the US? What are the requirements for the same, and what more do you suggest can be done?
Yes, absolutely. If they're presently on a visitor's visa, if and if they've entered legally, at least, even if they're not legal right now, you can file for them as a parent. And the only thing to keep in mind is how long they've been in the US. If they've entered on a B2 visa, was there an intention to immigrate at the time of entering on a B2 visa? Then there'll be a wrongful entry. So you have to make sure you give it sufficient time to show that at that time they did not have the intention to immigrate, like you're saying. Now you've decided to do so because of various medical conditions, etc. So you should be able to wait for 90 days from the date of their arrival, and then even if it comes up, you should be able to show that this intention happened after they arrived, or not, when they were still in India, if they were coming from India.
Okay.
So
Thank you.
you
Thank you,
file
Prashant.
for you file for an I-130 and 485,
Hmm.
and you would also file for advance parole if they just in case they need to travel, and you should be fine as long as you have all the documents and you file it properly. And I suggest making use of an attorney because these petitions are very involving, and there are a lot of issues that can come up which you may not know about, which you'll only come to know when you get an RFE, and then there's nothing much you can do about it. So always I suggest legal help.
Absolutely. Very well put. And all the best, Ishita. I hope you figure out, but definitely get legal help, consult an attorney, and why not talk to attorney Prashanti also. Contact her. Her details are here on the screen. And you can call her on this number, 212-354-1010. You can even email Prashanti at readyesq.com, and go visit the website readyesq.com to get to know more about Prashanti Reddy. Prashanti, thank you so much for taking that question up. And now I have this question from Shachin. I am an American. I am an American from Chicago, and my husband is Italian. We got married in Italy and will have been married for 2 years at the end of October. I have been bouncing between the US and Italy for about 3 years now. We are now more seriously considering moving to the US to work. Can anyone give me insight into what process would like for us? My biggest concern will be our ability to be physically together for the duration of the process.
I guess he's saying what would the process look like for us. My biggest concern will
Yes.
be our ability to be physically together for the duration of the process. If you want to be physically together during that time, then the only way to do it is um, for your spouse to come on some other visa, um, and you establish your residence here in the US since you've been out of the country. You should show that you've been living here for at least 6 months. And then after that, file for uh, an immigrant visa petition. I mean, you would file for adjustment actually and an I-130 approval. I-130 and 485 together if they're in the country. So come here, um, get another status for your spouse, or you come here, establish residency for 6 months. But I was not saying that because you said you wanted to be together the entire period of time, and that might be difficult in some situations. But if you
Mhm.
do, then your spouse has to find an independent way of being here because you do need to establish residency by living in the US before you file.
Okay. All right. All the best, Sachin. And thank you so much, Prashanti, for taking that up. And I think we are nearing the end of our webinar today. So it was great having you today discussing about sponsoring a spouse or parent. And this is something many of the immigrants have been dealing with. And thank you so much, Prashanti, for today. It was great. And before we go, if you have an end note for all the folks out there watching us today on this topic, it would be great.
I just wanted to take the time to respond to maybe Divya Sharma, who has a question.
Divya. Yes, let's take this up before we go. So sorry, Divya. Divya on YouTube is asking, I am a US citizen. My husband is an F1 student visa right now. I want to apply a green card for him. Do I need to meet the income requirements since he's already in the country?
Yes, everyone has to meet the income requirements, whether the person is in the country or not in the country. For a 485, it presumes that the person is in the country, otherwise, you can't file a 485. And for all 485 cases, you have to meet the income requirements. As I was saying earlier, if you don't meet the income requirements, your husband can chip in and file the I-864A, and you can show jointly that you meet the income requirements. If not, one of your parents can, if they're in the US, can file an additional I-864, or a close family member or a relative, or even a friend for that matter, can file I-864, an additional I-864 if they meet the income requirements. So that's the way to do it.
All right. Thank you so much, Divya, for your question. I'm so sorry I almost missed it. And thank you, Prashanti, for reminding also and for, yes, taking that up and for the detailed explanation. And with that, we've covered all the questions from our audience who dropped their questions. Thank you for your questions, everyone. And Prashanti, do you have an end note now before we could wrap up our show for today?
Um, I guess the end note would be that since we're talking about family-based immigration, and we are talking about how a lot of Indian nationals are filing now green cards for their parents, and they may not be aware of how to do it, or the fact that they can, in some circumstances, come on a visitor's visa and then file for an immigrant visa petition, file for a adjustment of status in I-130. Uh, Before presuming things, it's best to consult with an attorney, just take a consultation and see what the various options are for bringing your spouse or US citizen or parent, or child to the US. Um, Everything is not straightforward. Make sure you consult with an immigration attorney before you choose which path you want to take, whether it's consular processing or adjustment of status in the US.
All right. Thank you so much, Prashanti, for taking that up and for joining us today on this webinar. It was really wonderful having you discuss this topic with us today, sponsoring a spouse or parent. And folks out there, you can definitely contact Attorney Prashanti Reddy to have a one-on-one consultation and to discuss about yourself and your case. Her number is 212-354-1010. You can note it down. You can even email Prashanti. Her email address is prashanti@readyesq.com. And you can also go visit her website, www.readyesq.com, to get to know more about her. Thank you so much, Prashanti, once again for joining us. You have a wonderful day ahead.
Thanks, Nipasa. Looking forward to seeing you next week.
Me too. Thank you once again. All right, friends, thank you, you too, for joining us. It was lovely having your questions and also answering them. It was lovely having Attorney Prashanti with us. And friends, you could also contact me. My number is here on the screen in case you have any questions regarding immigration or are also looking for sponsorship, H1B or H4, TN visas, anything. Call me on this number. This is also my WhatsApp number. You can what message me in this number 408-335-6444, and my email address is nepa@highrightypeople.com. And to get to know more about us, go visit us at www.highrightypeople.com. Thank you so much for joining us. It was wonderful today discussing about sponsoring a spouse or parent and what are your options. And if you're watching this after the stream has ended, also please feel free to keep dropping your questions or your concerns in the comments, because we have our experts who will be more than happy to answer them. So also, if you resonated with this webinar and are looking forward for more interesting webinars or are an immigration enthusiast yourself, don't forget to subscribe to us, hit the like button, and share our content as well. Hit the bell icon and you will always be updated when we have discussions like this. Thank you for joining. This is Nipasa Pradhan signing off for now.